Good evening. My name is Alistair Reeder, co-president of the American Constitution Society, Boston Lawyer Chapter, and it is my great pleasure to welcome you to tonight's debate, Resolved, Citizens United Was Wrongly Decided. The event is sponsored by the National Constitution Center, the Federalist Society, and the American Constitution Society for Law and Policy, also known as ACS. There are many people to thank this evening, especially Anuj Kaderpal and Colleen Nevin from ACS Boston Steering Committee, Matt Scoble from ACS's National Office, Lisa Ezell from the Federalist Society of Boston, and Jen Darley from NCC. And we should also thank the John Adams Courthouse for sharing this historic venue. It's a great honor to be here tonight and have some of our justices present. I would like to remind you to silence your cell phones, but please do not turn them off. We would like to encourage you to participate in a social media discussion during tonight's debate. And you can use the hashtags of NCC Town Hall, ACS Law, and FedSoc. Please note also that the event is being video recorded, and the recording will be available later on the web. Since the Supreme Court issued its decision in January 2010, the Citizens United opinion has become inextricably intertwined with our views on democracy, speech, and the Constitution. The questions raised in this case are being asked and answered, debated and decided throughout the country. And tonight these questions will be asked and debated here. Tonight's event is just one of the many reasons that I am involved with ACS. ACS is an organization of legal progressives committed to the core constitutional values of genuine equality, liberty, and justice. With each generation, the U.S. Constitution has retained its authority and relevance, and with each generation, we must discuss, debate, and understand the legal and policy issues that define our society. ACS takes on that challenge across the country with lawyers chapters in 48 states and nearly every single law school. In the past few months here in Boston, our local chapter has had events on criminal justice reform, the Affordable Care Act, reproductive rights of teenagers, and balancing the state's role in social justice, to name a few. We appreciate your attendance here and hope that you will continue to join us going forward. It's the spirit of that thoughtful debate that brings us here tonight. So whether you're an ACS member, a Federalist Society member, a voter, or a public servant, welcome. Tonight's debate shows us that in our search for answers is not over, but alive and well with all of you. Our moderator tonight needs little introduction. Jeffrey Rosen is an attorney, journalist, and the president and CEO of the National Constitution Center. He's a graduate of Harvard College, Oxford University, where he was a Marshall Scholar, and Yale Law School. He is the author of countless articles and numerous books, including a book particularly relevant to tonight's debate titled Most Democratic Branch, How the Courts Serve America, where he explored the history and reception of key Supreme Court decisions that either predated or deferred to the constitutional views of the American people. Mr. Rosen is also a professor at the George Washington University Law School, a non-resident senior fellow at the Brookings Institution, and a moderator at the Aspen Institute. He received the 2012 Golden Pen Award from the Legal Writing Institute for his extraordinary contribution to the cause of better legal writing. And for these accomplishments and many others, he has been called the nation's most widely read and influential legal commentator. We are lucky to have him here with us tonight to moderate this important debate. Please join me in welcoming Jeffrey Rosen.
Thank you so much, Alistair. Welcome, ladies and gentlemen, to this historic John Adams Courthouse, the home of the Massachusetts Supreme Judicial Court, which I gather is the longest and most continuously running show in the judicial business. Basically, it's the most continuous court in the Western Hemisphere, and it is an honor to be in this beautiful building. Ladies and gentlemen, I can't tell you what a thrill it is to welcome you on behalf of the National Constitution Center. The National Constitution Center, for those of you who have not visited us in our beautiful museum on Independence Mall in Philadelphia, is a very special place. It's the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And that means that in these polarized times, we bring together all sides of the constitutional debates at the center of American life so that citizens can learn about, celebrate, and debate this great vision of human freedom, the U.S. Constitution. Out of all of the things that the National Constitution Center does, the debate that you are about to experience exemplifies our reason for being. Thanks to a generous grant from the Templeton Foundation, we've been able to unite the heads of the American Constitution Society and the Federalist Society to co-chair a national advisory board that is sponsoring a series of national town hall debates like this one that we think are like the Lincoln-Douglas debates. They are going to transform constitutional discourse in America. We launched at the National Press Club in D.C. about a month ago with a debate about whether the Hobby Lobby case was wrongly decided, and it was a riveting and meaningful experience to see two great debaters nominated by FedSoc and ACS having a respectful and engaged discussion, and you are about to hear one of those as well. In addition to these exciting debates, the National Constitution Center, with the help of the American Constitution Society and the Federalist Society, is building the best interactive constitution on the web, bringing the top liberal and conservative scholars in the country to write about every clause of the Constitution, describing what they agree about and disagree about. And this will be distributed by the College Board to every student in America. And finally, the Constitution Center hosts a series of podcasts, which you can listen to every week, and which are getting 400,000 downloads a month. There is a hunger in this country for civilized constitutional debate, and this is what the Constitution Center exists to host. It's now my great honor to introduce our co-host, the co-chair of our National Coalition of Freedom Advisory Board, along with Carolyn Fredrickson from the Federalist Society, from the American Constitution Society, and that is my good friend, Lee Otis. Lee is Senior Vice President and Faculty Division Director at the Federalist Society. She clerked for Judge Antonin Scalia on the U.S. Court of Appeals. She was a special assistant to Attorney Generals William French Smith and Edmund Meese. And I just have to tell you, ladies and gentlemen, when I approached Lee and her counterparts at ACS, Lee so enthusiastically embraced the spirit of this debate and has been such a close partner in sharing my conviction that it's important to bring all sides together. She is a friend and a great constitutionalist. Please join me in welcoming Lee Otis.
Thank you so much, Jeff. I am not going to keep you for very long at all. I just want to echo Jeff's enthusiasm and the enthusiasm of our friends at the American Constitution Society for this project. Bid you all welcome. Thank also our chapter leadership here in Boston, Greg Cody and Dan Kelly. I think Greg is here, so thank you very much, Greg. Also mention that our next event, our next co-sponsored event will be in New York on the NSA phone surveillance programs, and we are very much looking forward to a terrific event there with Judge Mukasey and somebody whose name I'm forgetting, but from, I think, Cardozo Law School. What? Deborah Pearlstein, I should know that, but I thought I was going to be closing rather than opening, but Jeff is accommodating me so I can catch the last shuttle back to Washington. So thanks everybody for being here, and looking forward to a great debate.
Wonderful. It is now my pleasure to introduce the debaters, and then I'll describe the format and introduce the case, and we will be off and running. Let me invite our debaters to the stage. John McGinnis, Anthony Johnstone, please join me in welcoming them. They need little introduction, and I will keep their introductions short. Anthony Johnstone is an associate professor at the University of Montana School of Law. He has testified before the U.S. Senate and the Montana legislature. He's been named by National Law Journal Appellate Journal Lawyer of the Week. He has been a litigation associate at Cravath, and he clerked for the Honorable Sidney Thomas on the United States Court of Appeals for the Ninth Circuit. It's also an honor to be joined by John McGinnis. He is the George C. Dix Professor forgive me for looking at Anthony because I'm looking at my notes. John McGinnis is the George C. Dix Professor in Constitutional Law at Northwestern Law School. He clerked on the U.S. Court of Appeals for the District of Columbia. He was Deputy Assistant Attorney General in the Office of Legal Counsel from 1987 to 1991. He's the author of Accelerating Democracy, Transforming Government Through Technology, and Originalism and the Good Constitution, and a past winner of the Paul Bator Award given by the Federalist Society to an outstanding academic under 40. This is a dream team, and you are going to hear the best arguments on both sides of this crucial case tonight. All right, we're here to begin our debate. We're using the same format which worked so well in New York and which we're taking on the road. There'll be 10-minute opening statements by each debater, followed by brief rebuttals of 5 minutes each, and then we'll have some Q&A from me and from you. You in the audience, please write down questions during the debate on note cards, which our great town hall director, Robin Morris, will bring to me, and I will read to the debaters, and then there'll be 3-minute closing statements. But here's the pitch, and there's a thrilling technological experiment which is taking place today for the first time in the traveling town hall debates short history. We are going to vote before and after the debate. And what I want you to vote about is not your political views, but your constitutional views. That is an important line that we are maintaining in these debates. We're not interested in your thoughts about whether campaign finance is a good or bad thing. The question is, what do you think the First Amendment requires or allows? And we'll vote before and we'll vote after, and we'll see whether anyone has changed his or her mind. In order to allow you to, this is a very informed crowd. I know you're all constitutionalists of the highest order, but I'm going to, as briefly as possible and with complete neutrality, try to describe the facts and the arguments on both sides of Citizens United, just to refresh your memory so that you can cast an informed vote, and then you'll hear the debate, and then you'll vote again. So you recall the facts of Citizens United. The case arose out of the presidential primaries of 2008. Hillary Clinton was a candidate for Senate from New York, and an advocacy group called Citizens United created a movie called Hillary the Movie. Trying to distribute and promote the film, Citizens United ran into the Bipartisan Campaign Reform Act, known as the McCain-Feingold Act. Passed in 2002, it banned corporations and unions from independent spending from their general treasury funds on electioneering communications within 30 days of a primary election. Citizens United challenged this as a violation of the Constitution, and the Supreme Court, in a 5-4 opinion, agreed that the act violated the First Amendment. A 5-justice majority led by Justice Anthony Kennedy overruled 2 previous cases which had upheld limits on electioneering communications, the McConnell and Austin cases, and the majority held that the government may regulate corporate speech through its disclaimer and disclosure requirements, but it may not suppress that speech altogether. There were 4 dissenters led by Justice John Paul Stevens, who argued that the majority violated principles of stare decisis, or respecting precedents, and also disagreed with the majority's interpretation of the First Amendment, insisting that in a variety of contexts we've held that speech can be regulated differentially on account of the speaker's identity, when identity is understood in categorical or institutional terms. All right, I think that's all I'm going to give you on Citizens United. You now have an opportunity to vote, so please take out your clicker, and what I want you to answer is the first question: do you agree with the Citizens United decision on constitutional grounds? So if you do agree, use the arrows on your clicker to select yes, and if you do not agree, then use the arrows to select no, and then hit send. And to turn it on, I think there is a button. Hold the button down, and it will miraculously light up, just like you will all light up with constitutional illumination after this debate, and then you can cast your votes. And of course, you'll approach the debate with a completely open mind, being willing to have your minds changed and have the possibility that your constitutional views might even diverge from your political views. Great. Has everyone voted? I think I see most of the clickers down, and therefore, ladies and gentlemen, it is my great pleasure to introduce Anthony Johnstone, who has 10 minutes to make his opening statement. Anthony.
Thank you, Jeff, and thanks to everyone for coming. It's a privilege to share the stage with John McGinnis, a constitutional scholar I greatly admire, and also one of the, I think we might be the only two constitutional scholars in America who also teach antitrust law. So we know our corporations, we know our First Amendment. I am proud to be an active member of both the Federalist Society and the American Constitution Society and advise both of the groups. I am also proud, Jeff will be happy to know, to have just joined the National Constitution Center. It's a privilege to join you from the great state of Montana, home to one of America's newest constitutions, here in Massachusetts, home to the world's oldest written constitution, at a courthouse named for its author, John Adams. John Adams is one of the founding fathers we can credit for inspiring the Bill of Rights, based modeled in part, on his Massachusetts Declaration of Rights. Unfortunately, John Adams also deserves blame in a First Amendment discussion for the Sedition Act, which criminalized criticism of his presidency and his party in Congress. At the time, the courts rejected constitutional challenges to the Sedition Act, and arguably, the Sedition Act was consistent with the original meaning of the First Amendment. It took we the people to act as the final judge of the Sedition Act, voting Adams out of office and electing Thomas Jefferson in a landslide in 1800. Now, nearly 2 decades later, Adams wrote to Jefferson in their poignant later life correspondence, "When people talk of the freedom of writing, speaking, or thinking, I cannot choose but laugh. No such thing ever existed. No such thing now exists, but I hope it will exist." Given his tragic relationship with the First Amendment, John Adams' comments are especially revealing. Freedom of speech and of press, as we know it, did not exist at the founding. Instead, the First Amendment has grown well beyond its original meaning into an innovative American ideal. Citizens United breaks with this ideal. It is unfaithful to the Constitution's whole meaning. It is inconsistent with our American traditions of politics, and it marks an unwise revision to our Republican form of government. Now, tonight, I'm not going to talk about the details of the particular federal law, but instead I'm going to focus on the adverb in tonight's proposition. Citizens United was wrongly decided because it was how Citizens United was decided, the reasoning that was at least as pernicious as what it actually decided. So first, Citizens United is unfaithful to the Constitution's meaning. I'll start where James Madison started, not with the First Amendment, but with the Republican form of government he helped establish in drafting the Constitution. He drafted it to remedy the problems of factions, or special interests, as we'd call them today, that naturally arise in a free people. He discussed a republic, by which he meant a government in which the scheme of representation takes place, public officials representing their constituents, the voters, not their donors. The First Amendment is critical to the Republican principle, and it was framed as an individual right. Madison's first draft put it explicitly that it was a right of the people to speak and publish freely. As a Montanan might put it, we like our First Amendment rights the way we like our Second Amendment rights, individual, not collective. It is no more obvious, for example, that a multinational corporation has the right to campaign for a president than it would to establish a militia. Now, that's the meaning of the First Amendment. The 14th Amendment is important to those of us in the states who have seen our laws fall under Citizens United. After the Civil War, the 14th Amendment incorporated the guarantees of freedom of a free speech and free press against the states. The 14th Amendment is even clearer in protecting citizens and persons as individuals who can be naturalized, born, and be deprived of life. Again, these individuals' privileges, immunities, and liberties, they may be exercised in association with others, but law has always been sensitive as to how they are exercised. For example, corporations around the time of the 14th Amendment were understood to enjoy the rights to property, certainly, but not to life or liberty, which belonged only to natural persons. So Citizens United is unfaithful to this meaning of these provisions of our Constitution. Citizens United is also inconsistent with our political traditions. And a word about them. Now, elections started in the United States, in America, through people who stood for election. And they'd stand for election, they'd offer treats. It would be called treating. They'd buy liquor for their constituents. And they'd fund it out of their own pockets. Landed gentry, usually standing for election. That changed in the Jacksonian era as elections became larger and more expensive. And the candidates turned to the spoil system and assessments where they'd appoint party loyalists and then tax their public earnings on the benefit to the benefit of their campaigns. After the Civil War, civil service reform started to dispose of the spoil system. And candidates turned to new donors. In the Gilded Age, this meant corporations, corporate treasuries, and their officers. Those corporations obliged and campaign expenses ballooned. Now, for the first time, around the time after the 14th Amendment, our political campaigns were no longer funded mostly by the candidates or the party members internal to the system, but by outside interests, what Madison might call the factions themselves. And almost as soon as those corrupt acts began, the states reacted with what they called Corrupt Practices Acts, prohibiting corporate campaign spending. Soon more than two-thirds of the states and the federal government had Corrupt Practices Acts. And this had been the status quo for most of the 20th century, sustained by the Supreme Court repeatedly, and as late as 2003, until Citizens United broke with this longstanding tradition. Finally, Citizens United is unwise in that it marks a departure from the wisdom of Madison's scheme of representation in a Republican form of government. The Supreme Court did not need to decide Citizens United broadly. Its lawyers actually dropped the constitutional challenge that the court decided to decide. But when it did, when it decided it on the broadest possible grounds, it collapsed Americans' historical Republican conception of corruption of this scheme of representation, interfering with the relationship between the representative and the represented. It collapsed that all into little more than quid pro quo bribery. As late as 2003, the court recognized a concern not confined just to the bribery of public officials, but a broader concern extending to the broader threat of political officials being too compliant with the wishes of their contributors. Just 1 year before Citizens United, its very author, Justice Anthony Kennedy, wrote in the Caperton case of his concern about the significant and disproportionate influence by independent expenditures, the very thing that Justice Kennedy created a constitutional right to make in Citizens United. That concern faded in 2010 when the court infamously announced a revised form of republicanism, saying it is in the nature of an elected representative to favor certain policies and by necessary corollary to favor the voters and contributors, to favor the contributors who support those policies. Later in McCutcheon, the court doubled down, saying that constituents, meaning donors, not voters, donors, have the right to support candidates who share their views, and representatives can be expected to be responsive to their donors' concerns. That's now the expectation, that representatives represent their donors, not their voters. Finally, in Williams-Yulee, a recent case, there was a little spark of hope, perhaps, dealing with judicial elections. The majority of the court, the 4 liberals who dissented in Citizens United, plus Chief Justice Roberts, distinguished a judge from other elected officials and implied that most elected officials may follow the preferences of their supporters and provide special consideration to their campaign donors. This is an astounding new formulation of Madison's old scheme of representation, placing the contributor, not the citizen, at its center. This is not republicanism. It is factionalism veering towards plutocracy, and Citizens United is to blame for it.
Thank you so much for that opening statement. John McGinnis.
Oh, well, thank you very much, and thanks both to ECS and the Federalist Society for inviting me, and I'm very grateful to share a stage with Anthony Johnstone. We've had the pleasure of being at seminars together, and I think he has a great career ahead of him. I would like to begin with discussing a bit about the facts of Citizens United, because I'm only here to defend Citizens United and not the entire jurisprudence of campaign finance of the Roberts Court. And it's important to understand what Citizens United is not. We've heard a lot about donations and contributions. This is not a case about individuals contributing or corporations contributing to candidates. It's also not about even expenditures coordinated with that candidate. Those can be prohibited completely consistent with Citizens United. And it's not even about undisclosed contributions. The Supreme Court was very clear that those contributions and indeed independent expenditures could be disclosed. It's actually about the question of whether some of our fellow citizens can come together using the corporate form to express their independent views about a candidate in an election. They wanted to express their views about Hillary Clinton in this case. And therefore, the narrow question in this case is not about the question of whether you can contribute to candidates, but the question of whether citizens who come together lose their ability to express themselves about a candidate because they use the corporate form. And we actually have a lot of case law on that question. New York Times versus Sullivan, I'm sure most of you have heard about that, was a case about a corporation, and that's where one of our most important First Amendment rights was forged, the right to criticize a public official without regard to libel. And that was a corporation, and moreover, note that it was citizens taking advantage of the New York Times corporate form. That was a group of people who put an advertisement in a newspaper complaining about conduct in Alabama. Or even more clearly, in Mills versus Alabama, the Supreme Court struck down a rule very much like McCain-Feingold, though that it applied also to the press and press corporations, that made it improper to criticize a candidate within a day or two of an election, very similar to the McCain-Feingold law. And these were corporations, and they were protected by the First Amendment. And of course, it's not only in the context of media corporations that corporations receive protection in the First Amendment. Our whole commercial speech doctrine has been brought about by corporations bringing First Amendment challenges. So the idea that corporations are excluded from the First Amendment is just not the case according to the great weight of First Amendment law. And I think it's a great mistake, again, when we talk about independently coming to an election, to think that we should exclude corporations. Because note that Citizens United, whether or not we had Citizens United, rich people could spend millions of dollars on the election, regardless of whether they used corporate form. As an actual result of Citizens United, they actually made it easier for people of more modest means, like those in Citizens United, to come together and express themselves. So I think there is a wrong view also about the consequences of Citizens United. I think it's so important to understand that the Supreme Court has protected corporate speech again and again and again, because what is at stake in Citizens United is something that's very important. The court ruling by neutral principles, applying the idea that corporations get the advantage of the First Amendment right across the First Amendment and not picking and choosing. And of course, neutral principles are part of the rule of law, but they're particularly important in the context of campaigns. I mean, it's frequently said, I don't want to be insulting to any federal judge in the room, that a federal judge is someone who knows a senator. And it's a little bit of concern, of course, a particular concern if they're not applying principles neutrally in the context of campaign legislation, when, of course, politicians would like to use that legislation to be reelected. Another reason that it's very important to apply neutral principles in this context is that the First Amendment, above all, represents a distrust of government. And the judiciary is part of government. And when we have distrust of government, we need to rule by clear rules and principles. And that's the reason I think that this case goes to the rule of law as well as the First Amendment. Now, it may be said that the Supreme Court in Citizens United overruled some prior precedent. It's not the case that it overruled precedents from the 18th century and much of the 19th century, much of the 20th century. It overruled two precedents, but they were against the great weight of the decision that we do protect corporations under the First Amendment. And I think it's right to protect corporations under the First Amendment. The First Amendment reads, Congress shall make no law respecting the freedom of speech. That doesn't make a distinction of the kind of entity that gets this protection. It's a prohibition on Congress. And whatever the 14th Amendment does, and actually I would say that's even a separate question of how far we should apply Citizens United to the states. Citizens United was a federal case. It's quite clear from the language of the Constitution that it doesn't make any sense to distinguish corporations from persons. I mean, why should someone lose their right when they join together in a partnership to speak? And if they don't lose it in a partnership, why should they lose it when they have a nexus of contracts to make a corporation? The whole point of the First Amendment is to empower people against the state, and that means it's useful for people to be able to come together and, again, speak independently about their government. It's a good thing that people can come together in associations. That makes their voice heard over the government and over people of great individual wealth. And so let me just end my discussion here by pointing out another aspect, what I think is relevant to defending the case in Citizens United. Although it was not really decided on exactly this reasoning, I think it very much supports this reasoning. I think one should see the Citizens United actors as really the modern equivalent of Tom Paine. They're writing a pamphlet. What is a video, a movie? It's the modern kind of pamphlet that they're trying to bring to the attention of their fellow citizens. And the point of the press clause is to protect the use of the press at that time. And this is what they're doing now, just as Tom Paine and the pamphleteers at the time in the 18th century, I think, were appropriately protected under the First Amendment, regardless of the Sedition Act, which I certainly think was incorrectly an interpretation of the First Amendment. They are the equivalent today of the pamphleteer. And you might say, well, maybe we only should allow the press, the institutional press, to have that authority. I mean, the press is a whole group of corporations, and though maybe they should be uniquely allowed to have that. But there's nothing about that in the press clause. The press clause seems to be an activity that's protected. The activity of publishing, of disseminating one's views. Or to put it another way, it doesn't matter whether you own the press or, like those citizens in Alabama, rented a press to put in their advertisement. They're protected by the ability to disseminate their views through the press clause. Indeed, it would be, I think, in some ways shocking to limit, as the McCain-Feingold attempted to do, the privileges to speak around election about candidates to the institutional press. Why should only Rupert Murdoch and the Sulzbergers have the ability to editorialize and influence people around an election time? Moreover, I think it would be self-defeating and deeply disturbing to the First Amendment. How are we going to distinguish between the institutional press that has the privilege, indeed often through corporate form, of editorializing and reporting on elections, and the rest of us? I think that's deeply antithetical. It would create the ability of the government to make those distinctions, would allow the distinction essentially, allow the government essentially a power of licensing to create a scribal class. Thus, Citizens United is not only about freedom, it's about the rights of citizens to participate equally in our society, to make sure that we do not have any particular privileged class. That's the bedrock of the United States. Thanks very much.
Thank you, John McGinnis, and thanks to both of our debaters for their eloquent and perfectly timed opening statements. It's now my pleasure to call on Anthony Johnstone for a 3-minute rebuttal. Sorry, 5-minute rebuttal.
I'll try to get it done in 3.
Great.
Well, I think there are places where John and I agree. But in terms of the neutral principles and the idea of the First Amendment as being a vehicle, and I agree with this, as a vehicle against the entrenchment of office holders in office, a lot of the Corrupt Practices Act, the Corrupt Practices Act I defended on behalf of Montana, was passed by initiative. It was the people themselves who put these into place. They weren't defending incumbent office holders. They were trying to dislodge them. But that's hard, you see, because the evidence suggests that corporate contributions are far more likely to be used to keep incumbents in office and to defeat challengers and maintain a status quo on behalf of their interests than other sorts of expenditures. So when we talk about neutral principles safeguarding government against entrenchment, we must ask about the facts. Do they actually entrench, or do they help to make elections more competitive? The record on corporate expenditures is decidedly mixed or negative on that account. In terms of neutral laws and not picking speakers, well, as long as a law is neutral, and we may debate whether they're content neutral or viewpoint neutral, but as long as they are neutral, the court has a long history of distinguishing between speakers, between nonprofits and business corporations, between foreigners and Americans, as the court did in a one-sentence dodge in the Blumen decision, between federal workers and other employees, between students and non-students, between unions and employers, between veterans and non-veterans. The court has a long history of drawing these distinctions. I think that there's at least as much merit in drawing that distinction in the instance of Citizens United. With respect to media, again, I agree with John that the discussion of the press is a reference to a technology, not an industry, a privileged industry. And I think that the early materials suggest that. In fact, Kentucky, in the teeth of the fight against the Sedition Act and Jefferson's Kentucky resolutions, adopted an amendment to its constitution that said that printing presses shall be free to every person who shall inquire and essentially oversee the government, criticize the government. So I agree with that, and there is a good argument. It's an argument that Michael McConnell has made, that freedom of the press properly protects corporate publications, including campaign materials, books, and even movies like Hillary the Movie. As I said, I'm focused on the adverb here, not the subject. But that argument would not require Citizens United to go as far as it does and make the unsupported assertion that independent expenditures do not corrupt. That argument does not support the lifting of corporate and individual contribution limits to super PACs. It does not lead to the subsequent decisions we've seen that have continued on this road of saying that it is the duty of a representative, the proper duty of a representative, to represent supporters, contributors, or expenditures under Citizens United's cramped view of corruption. So I'm willing to hear the press argument, but that argument was not made by the court in Citizens United. Were it made, I think we'd have a lot less to debate here. Finally, with respect to whether independent expenditures corrupt, it has just been proven false. It wasn't true when it was decided, and it hasn't been proven true since then. There is no difference. Ask a presidential candidate. There's absolutely no difference to the current crop of presidential candidates between a contributor to their independent super PAC or to a direct contributor. The only difference is the triage that they're playing with the campaign finance rules. The corruptive potential is just as equal with respect to independent expenditures. In fact, again, as Michael McConnell had said, the sunny dismissal that the independent expenditures don't corrupt is naive or obtuse. In fact, I think it's possible that independent expenditures can be more corrupting. They allow you to extort from, rather than just bribe, a office holder by making threats of the kind of attack ads without accountability, and in some cases, at least under current law until it catches up with Citizens United, without disclosure.
Thank you so much for that rebuttal. John McGinnis.
It's an interesting discussion, primarily because it shows the question of what are we debating when we're debating Citizens United, because Professor Johnstone began by saying, talking about the Montana Initiative. That would, of course, not be the Citizens United case. The Citizens United case is about the federal government. That really depends on another doctrine about how far we're going to apply the First Amendment to the states, whether we're going to consider initiatives as different. The court may well be wrong about that. I'm more sympathetic to that proposition than I am to the proposition that Citizens United is wrongly decided, which is what I thought we were debating tonight. I do think, though, it's important to note that when we should be quite suspicious of legislatures who restrict the rights of people to come together using whatever form they do, there's a lot of indication that the McCain-Feingold case was an attempt to make it easier for people in Congress to be reelected. First of all, people in Congress begin with a lot of name recognition. With the same amount of money, they're actually likely to do better. And that's one of the reasons they want to tamp down on independent expenditures. Moreover, independent expenditures are something they really can't in any way control. It makes the world much more uncertain to them. And I think it's not irrelevant that McCain-Feingold also contained other provisions that were absolutely incumbent protection acts, things that made it harder for millionaires to spend their own money in elections. That's the great thing an incumbent fears, that someone with a lot of money can self-fund. So there's a lot of indication from the legislation itself that we should be extremely suspicious of that kind of legislation. And then the point, I really think it is something of a concession that, that it is a problem we should accept that the people of Citizens United should have been able to use their corporate form to disseminate information. That was what was at issue in the case. Nothing in the case was about contributions. Nothing in the case was actually about the ability of the government to stop coordination of independent expenditures. The essence of the case was that simply because they used the corporate form, citizens could not come together and express their joint views. I think that's extremely troubling, and I think it's extremely troubling to make those kinds of distinctions, because it creates one class of citizens who are privileged to comment on an election against another class of citizens who are not. And that may also have political effects. I dare say that many of you have heard that the National Press Corps and the editorial writers around the nation are not exactly representative of the rest of the citizenry. And I think that's not a surprise. That's very much a specialized industry. And so I think we're actually likely to get a less insular politics, a politics that has open to people of all different kinds of views, if we allow people to use the corporate form to publicize their views at election time. That was the essence of Citizens United, and that's why it was rightly decided. Whether or not we could have a debate, and I'm happy to go into it in questions and answers about how corrupting contributions are, even there I think we have to look at it in the context of other ways of influencing government. If we constrain contributions, as we see in other nations, people are going to curry more favor from the people who are going to have more power, which is likely also to be the press. But nothing about Citizens United suggests that the government doesn't have substantial ability to constrain contributions to politicians and prevent coordination of independent expenditures. Indeed, I would favor some substantial strengthening of the coordination disabilities when you make independent expenditures. But we need to protect that independent voice precisely so that the campaigns don't become under the control of politicians and the press. We want to have our citizens come in and have the resources to come in to buy and to rent the modern equivalents of the press to make their voices heard. That's, of course, troubling to politicians, because that means the campaign may take off in ways they can never imagine. That's why they'd like to suppress it.
Thank you very much indeed for that rebuttal. Ladies and gentlemen, it is time for question and answer. I'm going to ask a few, and then I will read yours. I should warn you that I need reading glasses, so write clearly and continue to write down your questions and hand them to Robin Morris, who will collect them. Gentlemen, I want to begin with constitutional text and history, and I will take out my copy of the National Constitution Center's Pocket Constitution, which has a thrilling new introductory essay about the relation between the Declaration of Independence and the Bill of Rights by yours truly and David Rubenstein. And I'll read from the text, which I can probably get without my glasses, but I want to get exactly right. And it says, it's worth waiting for. Congress shall make no law abridging the freedom of speech or of the press. So, Anthony Johnstone, I want to ask you how the framers originally understood that language. Justice Stevens, in his dissenting opinion, has a lot of historical claims that the framers had a deep mistrust of monopoly, dating back to Thomas Jefferson, that they proposed anti-monopoly amendments, that continued through the Jacksonian era and the trust-busting era, and basically that they viewed corporations as differently than natural persons. Justice Scalia responds that the framers wouldn't have thought about the modern corporation because they were concerned about state-granted monopolies and not modern corporations. And aside from Thomas Jefferson, most of them would not have shared this anti-corporate bias. Who is correct, Stevens or Scalia?
Well, Jeff, there are two questions in terms of the original understanding of the First Amendment generally, or the original meaning generally, and that is up to debate, like the other clauses in the First Amendment, the religion clauses. The meaning of expressive and religious liberty was evolving at the time, and so you have old forms that said basically the First Amendment was just a guarantee of a right to trial by jury, the right to use truth as a defense, both provisions that were respected in the Sedition Acts. But there was a new version, a Jeffersonian version, I guess, that had a more expansive view of freedom of expression and expressive autonomy. Now, the relation of that to corporations is difficult to translate today because, frankly, they did not deal with general business corporations. Those didn't come into effect until after the Civil War, after the 14th Amendment. That's why the 14th Amendment is illustrative of this point. How did the 14th Amendment, what was the 14th Amendment's mention of citizens, of persons who held these rights? How was that informative of it? And that suggests that these were individual rights rather than collective rights. Again, not to say that individual rights can't be authorized collectively, but there has never been in the law an absolute right to expressive association that John would confer upon corporations.
Thanks, John. The same question to you. Who is correct in the historical account of corporations and free speech, Stevens or Scalia?
Well, I want to say that I think that's not clearly the relevant question. The relevant question is the language of the First Amendment, which focuses on Congress's disability in regulating the freedom of speech. So I don't think it is strictly relevant. Now, maybe if there was some ambiguity in that, we should look to those expected applications, but I see the structure as a distrust of Congress. It might be different, of course, at the time with respect to the states. And it's a concern that Congress, which I think we see in the modern acts, is going to act inappropriately with respect to freedom of speech. The one thing I would want to add there is, though, that the idea that corporations aren't protected under the First Amendment, at least as it is understood, would make media corporations at the mercy of the government.
Anthony, your response to that point. John said the history doesn't matter because the text is clear and the framers clearly distrusted government, and Justice Kennedy makes the exact same point. Are you persuaded by that, and do you agree with John that the different treatment of the press belies that claim?
Well, I'm disappointed that I was expecting more Scalia than Kennedy from Professor McGinnis, who is well known as an innovative originalist methodologist. So I guess we do want to look at the original meaning in terms of whether, yes, it's about restraining people from government. But again, the point is that never in our history has the court accorded associational rights? Absolutely. And never has the court read, although Justice Black at times might have convinced himself that they've read, Congress shall make no law to mean that Congress shall make no law. There have always been some play in there and some recognition of the American traditions that had created the current First Amendment doctrine we have, the doctrine that we had before Citizens United, and the doctrine we now have that takes a more absolutist, libertarian approach to these campaign finance issues.
John, I'm going to ask another question about original understanding. Justice Stevens, in his dissent, says the framers had a much broader understanding of corruption than the majority does. They were concerned about the dependence of legislators on private interests and would not have limited their understanding to quid pro quo corruption. Do you think that that is historically accurate or not?
I don't think it's historically accurate in this sense. I think people were concerned about corruption, but the whole purpose of pluralism and the First Amendment recognized that people would have differential influence on the government. And so it's very important to make a distinction between corruption and why the court tries to constrain it to quid pro quo corruption as opposed to influence. Because the whole point of the First Amendment, the natural consequence of the First Amendment, is that different people are going to be more influential in government. And that cannot be defined as corruption. And that is, I think, the real concern. In fact, it was the stated concern with respect to the McCain-Feingold Act, that this would create a kind of distortion. It would give some people more power over the other. The fact is, in a democracy, we're going to have people of differential influence, and the First Amendment is a right of free speech. It's not a right of equal speech, and so it's a natural consequence that there'll be different amounts of influence. So I don't think it's consistent with the First Amendment to enlarge the sense of corruption beyond the kind of corruption the court is talking about, because that, I think, really disturbs the ability of people using their rights to have different influence. People are differently eloquent, they're differently situated, and actually that sort of private social ordering, that private social ordering is very important to the government. Otherwise, there's not going to be a counterweight to the government. The framers, I think, are much more accepting, actually, than many people in the modern world, of differences in talent and differences in influence. So I don't think Stevens is correct in that respect.
Anthony, this question of whether the framers thought that people would have different influence is crucial to whether or not the Austin case was correctly decided. The Austin case, which the court overturned in Citizens United, said that in order to equalize the speech market and ensure that corporations don't have undue influence and drown out others, it was permissible to restrict corporate speech. The majority overturned Austin on the grounds that even the government had not defended it on those terms and instead was focusing more narrowly on influence corruption. Was Austin correctly decided, or was the court correct to overturn it?
Well, I guess, first of all, in this question of treating corporations differently, it's worth just to set the record straight. Citizens United had a budget of $12 million. Citizens United was a corporation. It was a nonprofit corporation. It was free to spend in elections as a nonprofit corporation, according to a distinction the court itself had drawn in 1986. With a budget of $12 million, it decided to take, I think, about $2,000 from general corporate treasury funds to create a test case. There's no doubt that Citizens United was free to spend. There's no doubt that the corporate funders of Citizens United were free to find other outlets, including through segregated funds and corporate PACs, to spend their money. No one is being silenced, and the court's suggestion that these corrupt practices act silenced corporations, or as Justice Scalia put it, muzzled the principal agents of the modern free economy. Well, take a look at American politics, say in 2009, and tell me whether you think the agents of the modern free economy were muzzled before then and have suddenly been freed up. So corporations have always had a role and have always had a voice in American politics. The question is how they speak, not whether. Austin, to the extent it expressed a particular concern, and by the way, respected the place, Austin involved states. So I disagree with John. Unfortunately, Citizens United did reach a 14th Amendment ruling as Montana became aware of it when it got the back of the court's hand in a 2-paragraph summary disposition, the first one in 40 years invalidating a state law. Citizens United did, or at least the court did, think it was deciding the 14th Amendment issue as well. Austin, to the extent it respected that tradition and respected the traditional concerns of corporate influence in politics while preserving a voice for corporations in politics, I think was correctly decided to that extent. Whether the government was correct to defend the so-called anti-distortion interest or a kind of equality interest, an equalizing interest, that's a trickier question. I think the government knew its audience and was not going to play a losing hand there.
John, I think I detected a bit of Montana pride in Anthony's remarks, and indeed the Montana Supreme Court, in a subsequent opinion that he referred to, said that Justice Kennedy was wrong when he predicted that the removal of caps on corporate speech would not lead to citizens' lack of confidence in government. And they said empirical evidence in Montana proved the opposite. What is your response to their claim?
I think that's rather diffuse evidence. It's essentially people's, it's really in the eye of the beholder. Moreover, I think there are many other ways, and I think this is an important point, for the government to encourage confidence in government rather than suppressing speech. For instance, if one is concerned, I think this was the kind of concern in Montana, is that if corporations had independent expenditures, that they might get special favors from the government. Well, I think there are a lot of things government can do other than to suppress speech. They can require that legislation be more general. Congress actually, after Citizens United, got rid of earmarks. There are many ways of restoring confidence in government, and I think it's just a mistake to understand any decline in the confidence of government as coming from more robust debate or more contributions. It's come really from the size of government and the inability of government to constrain itself. So in some sense, I understand why people have lost confidence in government, but it's just, it's mistaking a symptom for the disease.
Great. Well, I'm going to start with our excellent questions, and I'll begin with one from Thomas Jefferson. It's a quotation, and it says, "The end of democracy and the defect of the American Revolution will occur when government falls into the hands of lending institutions and moneyed in corporations." Wow, a learned member of the audience who has Jefferson memorized. Anthony Johnstone.
Jefferson's not here?
Absolutely. He is here in spirit, along with Adams, who's disagreeing with him. Discuss Jefferson's statement and its relevance to Citizens United.
Well, I think this goes back again to this effort to develop, apart from whatever the original common law meaning of the freedom of speech or freedom of the press might be, to develop a distinctive American ideal of free speech and free press and free exchange of ideas. I think we saw that in the debate over the National Bank, in which we saw that in the early Marshall cases, in which corporations, Chief Justice Marshall in the Dartmouth case talked about corporations. Madison talked about corporations as being these legal constructs, these legal fictions, not natural things imbued with rights. So I think what Jefferson is telling us is that we should not be as confident. Whether Stevens is right in his dissent, there's more work to be done, but we certainly should not be so confident as originalists like Justice Scalia and Justice Thomas in asserting that the First Amendment provides as easy an answer as Professor McGinnis says it does with respect to Corrupt Practices Acts.
Great. John, let me just ask you, I know you think the text is clear, but you're a distinguished historian. Is it, and Jefferson clearly did, there is an anti-monopoly tradition that goes back to Jefferson and the anti-federalists. There's also a pro-monopoly tradition back to Hamilton. Is the history clear one way or the other, or are there basically two competing traditions that have been warring it out throughout American history?
There certainly have been two political arguments that have been warring it out through American history. Again, I think that's different from understanding the Constitution. My focus on the Constitution has been that there's no focus on the kind of entity that's getting the freedom of speech. And I think that it's a mistake to read into the Constitution a victory for the Jeffersonians in that respect. I just don't think that's the case. And I want to make very clear, I think there's a monopoly concern on the other side, and that's why the Supreme Court has never made a distinction giving the press greater privileges than other individuals. That's a monopoly power. I think the press has much more influence in elections than any financial interest, certainly any financial interest coming out of Citizens United. It's important to understand that after Citizens United, the amount of money that large corporations, Fortune 200 corporations, have donated is still an extremely small amount of money. They're worried about annoying their customers, but the power of the press is actually is extraordinarily great. I'm not against it, but I'm against the monopoly power of the press. And I think that's what the McCain-Feingold does. So if we're actually talking about monopoly, we have an anti-monopoly principle on the side of the majority in Citizens United.
Great. All right, we have so many good questions that I'm going to pose them to one or the other of you, and the other can chime in if he likes. Anthony, should contributions by unions be limited to any effect?
I think unions present a different historical setting. They're empirically shown to be much more aligned with voters in general, including some very important recent empiricism from Professors Gilland and Page at Northwestern. That's why Montana and certain states drew a distinction. But I think that unions also present a factional concern. And in current, after Citizens United, have been spending at least as much, actually more than corporations have been in federal elections. So I think in terms of the interests, the federal balance and the balance of treating corporations and unions both as possibly dangerous factions for purpose of spending is defensible. I guess the bigger concern is that the court appears to be headed towards a double standard in which it is protecting union members' rights not to have to pay dues to unions for political expenditures, but rejected corporate shareholders' rights not to have to pay involuntarily in many cases through pension plans and institutional investors, not protecting corporate shareholders. So I'm more concerned, both unions and corporations present factional concerns. The real concern, though, is that the court is now moving towards a double standard where it's not going to let unions speak while letting corporations speak.
Thank you. John, do you agree that anonymity in campaign donations impacts their corrupting effect?
I think it's very clear in Citizens United that, first of all, I want to be again clear that it's not a donations case. It's a case of independent expenditures. But the court is very clear you could require disclosure of independent expenditures. And I think that's a very good idea. I think there are bills in Congress to try to make that better. And I think that should happen. I certainly think, I don't know if it impacts corruption. I certainly think it's very relevant who's supporting which candidate, and that's information that helps us make an informed decision. And again, that's consistent with neutral principles. In other areas, except in extraordinary instances, as when the NAACP was under threat from the Klan and other people in the South, disclosure laws have been permitted. And I think disclosure laws are clearly permitted and are clearly warranted with respect to both independent expenditures and to donations in a donations case.
Thank you. This is for Anthony. Do you believe that nonprofit citizens advocacy groups, virtually all of which are incorporated, should enjoy First Amendment rights? And if so, how would you draft and enforce distinctions between business and nonprofit corporations?
Well, I don't have to, because the Supreme Court did in the 1986 case of Massachusetts Citizens for Life, Massachusetts. And the court was clear that certain expressive associations, again, this is the neutral principle. This is general First Amendment doctrine, that certain corporations were expressive associations who were more burdened in the exercise of their expressive association. through a corporate expenditure ban or the requirement of a segregated fund, a PAC, than others. And the court drew that line quite clearly. It held for more than 2 decades, and the court in 1986 was clear that those did not present the problem of acting as conduits for corporate treasury funds in the way that the business corporations that were the subject of Corrupt Practices Act did. So it was a line that the court drew, and it's one that held firm until Citizens United. Citizens United, again, could spend. The only reason Citizens United went to the Supreme Court is because it took $2,000 out of a $12 million budget of general corporate business money. That's the only reason. Otherwise, it was on the other side of a very clear line. Everyone knew it was there.
I'd like just to intervene a bit in this. I mean, I don't think that's a principled line. Media corporations are for-profit corporations that use their general treasuries to pursue their activities. So I don't think that's a principled line. I don't think the First Amendment should make therefore a distinction between for-profit and non-profit institutions. I think there it's an attempt to read sort of a social democratic constitution, which I certainly don't think the framers accepted, that there's something more, that there's something base about seeking profit, and we don't want to have that kind of entry into our political life. Everyone has interests. Nonprofits have interests. The media has interests. For-profit corporations have interests. That idea of drawing the line there, I think, is not supported by the Constitution's text, and it's actually an importation of some idea of social democracy that the commercial republic, which the framers, I think, bequeathed us, is somehow needs to be tamed.
A very quick quote from that famous social democrat, Michael McConnell, Federalist Society friend. Americans have a First Amendment right to do what we can to sway public opinion, which is to publish directly. That's not what the business corporations were doing in Citizens United. They were simply making contributions to fund someone else's speech, and that's an important line. Again, the court might have been more nuanced about that argument, but it wasn't. There are good arguments to be made, maybe for corporate press rights there, but they were not made and are not at issue.
Great. We have time for 2 final brief questions to John McGinnis. If a state were to condition access to the corporate form on an agreement to comply with campaign finance laws, would that constitute an unconstitutional condition?
I think that's quite clear under the court's jurisprudence. I don't think one can, the courts, whether or not we agree with unconstitutional conditions is another question. We could have a debate about that, but it's quite clear that the state can't condition privileges on giving up rights. That's clear with respect to being a public employee, a whole variety of areas. So I don't think there's any argument that that's a good way to conceive, at least in the modern case law, of how to deal with corporations.
Great. Last question to Anthony. Can you articulate precisely how many of which speech rights are forfeited by articles of incorporation?
Again, it's a matter of heeding our tradition and paying attention to the fact that the court, I think Justice Stephen Field in the lower court before an 1880s case on corporate rights, began to elucidate a distinction that, not surprisingly, corporations do not have a right to due process in deprivation of life. Interesting questions in terms of liberty. Again, I am not the absolutist here. I think that corporations are expressive associations that should be treated as such under neutral general First Amendment doctrine. It is the court in Citizens United that has reified corporate status as being entitled to all of the rights, have talked about them being silenced when it was clearly not the case. Not even Citizens United was silenced. I am for the traditional American approach to corporate rights, which is an approach that is sensitive to our history and the roles of corporations. The absolutists are on the side of Citizens United, both with respect to the First Amendment and with respect to the 14th Amendment, notwithstanding its text.
Thank you so much for that. Gentlemen, it is time for closing arguments. They are 3 minutes each, and the first closing argument is to Anthony Johnstone.
Well, thanks, Jeff, and thanks to John. You've heard two perspectives tonight, and one had focused on the meaning of the whole Constitution's text and structure, illuminated by tradition and counseled by a healthy respect for the limited role of federal judicial power in a republic. The other had ventured far beyond the constitutional text and historical context into an unprecedented expansion of a controversial 1970s-era decision embracing aggressive judicial engagement in the political process. Of course, the punchline is that I'm the ACS guy making the traditional judicial restraint argument, and John is the Federalist Society guy making the broader celebration of this 1970s case of Buckley versus Vallejo. I just wanted to close in terms, I've talked about tradition a lot and its role in constitutional adjudication. This morning I walked a few steps of the Freedom Trail from those two shrines, between those two shrines of free speech, the Boston Common and the Old South Meeting House, which is, of course, across the street from the birthplace of Benjamin Franklin, the patron saint of the freedom of the press. Let's remind us that our constitutional principles are a collective achievement wrought over centuries by millions of people. More often than not, the Supreme Court has helped to sharpen and perfect those principles. At its best, it represents what Justice Harlan the Younger said in Poe versus Ullman. It represents a balance the nation struck between liberty and the demands of an organized society. Having regard to what history teaches are the traditions from which it developed and those traditions from which it, the nation, broke. I take some solace in Justice Harlan's dissent in Poe v. Ullman. He said, "A decision of this court which radically departs from this living tradition could not long survive, while a decision which builds on it is likely to be sound. No formula could serve as a substitute in this area for judgment and restraint." Unfortunately, Citizen United's broad approach to reframing our Republican scheme of representation and placing the supporters, the funders at the center of that, lacked both judgment and restraint. Fortunately, because it marks such a radical departure from how we, the people, conceive of our republic and our freedoms, it may not long survive.
Thank you so much. The last word to John McGinnis.
Oh, well, thank you very much, and thanks to Anthony for this illuminating discussion. There are many areas where the court should defer to Congress, but I think the last area is the First Amendment, when Congress is concerned about its own re-election. That is an area, the hard issue for the court is when to intervene and when not to intervene. And the answer to that is given in the Constitution together with our traditions. And our tradition is to be extremely skeptical of constraints on the freedom of speech, particularly when they are focused at election time and particularly when they are given to us by the members of Congress who may be subject to election. So I do think it is completely consistent with our tradition to be extremely scrutinize that kind of activity. I think it's also important to understand that Citizens United is not a case that prevents restrictions on donations, restricts donations on quid pro quo activities. It's a case that says, however you have your funds, we may be able to restrict the kind of donations you would get. That would be permissible. We cannot tell you how to spend your funds at election time to speak about candidates. That's an important right. That's the kind of right that people exercised from Tom Paine on in this country, people who are not necessarily members of the press. And that's what's so important about Citizens United. It affirms that all citizens have the ability to get part of the rough and tumble of politics. Note that Citizens United, whether we have it or not, people of tremendous wealth could spend a lot. to make their voices heard at election. What Citizens United does is allow people of more modest means to get together and coordinate their own activities, not with respect to politicians, and make their voices heard. That's an essential aspect of the democratic process. And it's particularly important that that process not be given over simply to politicians, who of course can speak as much as they want, and to the press, who are allowed by Citizens United, by McCain-Feingold, to speak as much as they want. What Citizens United says is that everyone is equal at election time, that we are affirming what the court had a long tradition of affirming, that every individual has the right to use the press to publicize their views. And just as the press can use the corporate forum to do so effectively, so can individuals gather together and use that forum, a partnership forum, because that's going to make their voice more heard at election time. And that kind of influence, however it is felt on government, is a good influence. That's what the First Amendment suggests. Any concerns about dealing with the confidence of government can be dealt with in other ways, through constraining the reach of government and not through constraining the ability of individuals to gather together and use a forum that will make their voices heard at election time.
Ladies and gentlemen, we're about to vote, but first of all, please join me in thanking our debaters for an illuminating discussion. All right, now comes the thrilling opportunity to test this new technology. This is constitutional high-tech at its most vivid, and I'm going to ask you two questions. First, the same question that I did at the beginning of the debate, and we'll see whether or not you've changed your mind, and that is, do you agree with Citizens United on constitutional grounds? And once you've selected yes or no, hit send, and of course, take account of the arguments that you've just heard. Once you hit send, your answer will be displayed back to you. That means your response has been recorded and transmitted in real time to our crack tallying team, which will be able in seconds to write it down on a note card and walk it up to the podium. Could also text it, but we want to make sure that nothing goes wrong here. All right, if you've all voted on that, we have our final question, which will appear momentarily on your remotes. Yes or no, I now better understand the opposing view. That's the question. Have your minds been open to the opposing view? And again, once you've selected your answer, please hit send. And as you are voting, and as our crack team is tallying your responses, I'm going to just tell you about these thrilling debates that we have coming up. As Lee Otis mentioned, in New York on June 16th, we will debate Resolve, the NSA's massed phone data collection violates the Fourth Amendment. You saw that the Second Circuit just last week struck down the mass data collection program, and we will debate its constitutional merits. Michael Mukasey, former Attorney General of the United States, and Deborah Pearlstein from Cardozo Law School, who recently participated in a superb Intelligence Squared debate that we did in New York about the president's war power abilities. In addition to these phenomenal Federalist Society and American Constitution Society debates, the National Constitution Center has a series of debates with Intelligence Squared, which is the very intelligent debating series whose debates are covered on PBS and NPR. And once again, there we debate not political issues, but constitutional issues. And it's striking in these Intelligence Squared debates, which is why I'm eager to find out the result of our vote tonight, to see how many people find that their political views sometimes diverge from their constitutional views and who changes their minds. In one of these debates, the audience had initially voted that the president does not have the constitutional power to target and kill American citizens abroad. And then after Alan Dershowitz gave the single best closing argument I've ever heard, the audience changed its mind and voted yes, he does have the constitutional power. So the power of these debates is that people can open their minds to constitutional arguments. We think, I'm obviously stalling for time as our results are being tallied. I think the experience that you've just participated in is important, transformative, and entirely in the spirit of the American founding. And therefore, I'm especially pleased that Nicandro, our crack web strategist, has brought me the results. We'll see if it makes sense. Stay here just to make sure I understand it. We should have had it in an envelope, and like
next time.
Next time, a constitutional envelope
Right.
for New York with some parchment. So, okay, we have the before and after. Oh, this is so exciting! My goodness, I just can't wait to share with you this riveting vote shift. And there has been some change in the vote. Ladies and gentlemen, before this phenomenal debate, 26% of you voted yes, we do agree with Citizens United, and 74% of you voted no, we do not agree with Citizens United. After the high-quality debate that you've just heard, 35% of you voted yes, you do agree with Citizens United, an increase of 9, and 65% of you voted no, you do not agree with Citizens United, a decrease of 9. You know, the way Intelligence Squared does it, the winning team is the side that has the biggest vote shift, and I'm delighted to report in this first use of the technology, both of you had an identical vote shift, so congratulations to our two winners tonight. And the final question, in some ways, is the most important one. We did try to formulate a way of capturing the civic value of these debates. And during the last one, I just asked who changed his or her mind, and I'm sorry to report, I think it was basically 0. I think one person in 200 may have changed their mind. So that may not be a surprise, because Justice Breyer has observed that when it comes to constitutional questions, people have strong views and they may be unlikely to completely alter them. But we do believe passionately that by giving the best arguments on both sides, you can open your mind and better respect the argument on the other side. And therefore, I am delighted to report that for the question, I now better understand the opposing point of view, a rousing 88% of you voted yes, and only 12% of you voted no. Congratulations to this open-minded group. I will just close by saying, I hope there's more booze for some final conversation, but it is a privilege to be able to bring together these great groups and great debaters to debate the most important constitutional issues of the day. This was substantive, it was meaty, it was intelligent, and it was constitutional, and it vindicated an observation that Justice Holmes, a great Boston justice who is often invoked by both the Federalist Society and the Constitution Society, said. Holmes noted, the Constitution is made for people of fundamentally differing points of view, and we believe that passionately at the National Constitution Center, and think that by bringing together the best arguments from those different points of view, we can illuminate and educate the public about this great document of freedom, the U.S. Constitution. Thank you so much. See you in New York.
Thank you very much. Thank you.
Nice job.